Constitution and facts and points. The Constitution of India was framed and adopted by the Constituent Assembly of India. The Constituent Assembly was set up in November 1946 as per the Cabinet Mission Plan of 1946. There were 389 members in the Constituent Assembly, of which 296 were elected by the member of the Provincial Assembly and the rest were nominated by the princely state. Out of 296 seats, 110 seats were reserved for the general candidate, 78 seats were reserved for the Muslim, 4 seats were reserved for the Sikhs, and 4 seats were reserved for the Chief Commissioner Province. The first meeting was held on 9th of December 1946 with Sachinand Sinha as a interim president. On 11th December 1946, the Dr. Rajendra Prasad was elected as the president of the Constituent Assembly and S.C. Mukherjee was elected as a vice president of the Constituent Assembly. Sri B.N. Rao was appointed as the legal advisor to the Constituent Assembly. The historical objective resolution was moved in the Constituent Assembly by Pandit Jawaharlal Nehru on 13 December 1946. The objective resolution proposed by the Pandit Jawaharlal Nehru and passed by the Constituent Assembly ultimately became the preamble of the Constitution of India. On 3rd June 1947, the Lord Mountbatten announced his intention to scrap the Cabinet Mission Plan. This culminated in the passing of Indian Independence Act 1947 and the partition of India into two dominion states, India and Pakistan. As a result of the partition under the Mountbatten Plan, a separate Constituent Assembly was set up for Pakistan and representative of the some provinces ceased to be member of the assembly. As a result of the membership of the assembly was reduced to 299 from the 289, out of which 229 represented British India and 70 represented princely state. The Constituent Assembly formed 22 important committees for framing the constitution. The 7-member drafting committee was appointed on 29 of August 1947 with Dr. B.R. Ambedkar as the chairman. On 26 November 1949, the people of India through the Constituent Assembly adopted, enacted and gave themselves the Constitution of India. This day is also known as Law Day or the Constitution Day. 284 members signed the Constitution only that day. The Constitution as adopted on November 26 of November 1949 consisted of 395 articles divided into the 22 parts and the 8 schedules. On this day, Article 5, 6, 7, 8, 9 and 60, 324, 366, 367, 379, 380, 388, 389, 391, 392, 93, 94, 392, 393, 394 came into the force and other article came into the force from 26th of January 1950. The Constitution of India is second lengthiest constitution of the world after the Constitution of Alabama. Overall, Constituent Assembly held 11 sessions and sat for 2 years, 11 months and 18 days to complete its task for drafting the Constitution. Constituent Assembly adopted the national flag on 22 July 1947 and the national anthem and national song on January 24, 1950. Constituent Assembly continued as a provisional parliament from January 26 of 1950 till 16 April 1952. It ceased to exist as provisional parliament on April 17, 1952. The Constituent 42nd Amendment Act 1976 amended the preamble and added the words socialist, secular, and integrity to the preamble. The preamble is non-justiciable in nature, like the directive principle of the state policy, and cannot be enforced in court of law. The preamble cannot override the specific provision of the Constitution. In case of any conflict between the two, the latter shall prevail. The preamble declared that it is the people of India who had enacted, adopted, and given the Constitution to themselves. Thus, sovereignty lies ultimately with the people. The word sovereign emphasizes that there is no authority outside India on which the country is in any way dependent. By the word socialist, the Constitution means the achievement of socialist pattern of the society through democratic means. The term socialistic pattern of the society was adopted as a goal of the Indian state by the Congress in 1955 in Awadi session. That India is a secular state does not mean that India is non-religious or irreligious or anti-religious, but simply that the state in itself is not religious and follow the ancient Indian principle of Sarva Dharma Sambhava. The Supreme Court in the Keswanandan Bharati versus State of Kerala 1973 cases made it clear that preamble is the part of the Constitution and is subject to the amending power of the Parliament as any other provision of the Constitution, provided the basic structure of the Constitution is not destroyed. The word republic means that there exists no hereditary ruler in India and all the authority of the state are directly or indirectly elected by the people of India. Article 1 says that India, that is Bharat, shall be the union of states. The term union was suggested by Dr. B.R. Ambedkar, which indicate that two things. First, Indian Union is not the result of the agreement of independent and sovereign state. And the second, the units and state do not have the right to secede from the union. Parliament under Article 3 can increase or diminish the area of any state, or alter the boundary or change the name of any state. The Indian Constitution empowers the Parliament to alter the territory or names, etc. of the state without their consent and concurrence. By a simple majority, by ordinary legislative process, Parliament may form a new state or alter the boundary, etc. of the existing state and thereby can change the political map of India. The citizenship is regulated by the Indian Citizenship Act 1955 as amended further in 1986, 92, 2003 and 2005. The Act provides for the acquisition of the Indian citizenship after the commencement of the Constitution in 5 ways: birth, descent, registration, naturalization, incorporation of territory. Incorporation of the territory. In India, there is a single citizenship, i.e., in other words, citizenship of India, not of the states. The Citizenship Act 1955 also laid down 3 modes by which an Indian citizen may lose his her citizenship. These are renunciation, termination, and deprivation. The chapter of the on fundamental rights so continue in the chapter on fundamental rights so contained in part 3 of has been described as the Magna Carta of India. Article 13 provides for the judicial review of all the legislation in India. The concept of judicial review is taken from the Constitution of the USA. Article 13. In Keswanandan Bharati versus State of Kerala 1973, it was held that the Parliament can amend any of the provision of the Constitution, including fundamental rights, by its amending power under the Article 368 provided such amendment do not touch the basic structure of the Indian Constitution. The Constitution of India contains provision for the automatic suspension of the fundamental rights under certain circumstances, e.g., exempli gratia, during the national emergency under Article 352, i.e., war of external aggression. The fundamental rights guarantee under the Article 20 and 21 cannot be suspended during the national emergency. Article 36 to 51 deal with the provision of the directive principle which are contained in Part 4 of the Constitution of India. It has been adopted from the Constitution of the Ireland. Article 37 states that the provisions contained in Part 4 of the Constitution, i.e., directive principle of the state policy, shall not be enforceable by any court, but the principle laid down in that part are nevertheless fundamental in the governance of the country and itself. The fundamental rights are in the form of the negative obligation of the state, i.e., injunction against the action of the state. The directive principle are, on the contrary, positive obligation of the state toward the citizen. Whereas the fundamental rights are the justiciable, the directive principle are not justiciable. The fundamental duties were included in the Indian Constitution by the 42nd Amendment Act 1976 by inserting the Article 51A, 4th A along with the DPSP. The Constitution 86th Amendment Act 2002 added a new fundamental duty as itself the duty of every citizen of India who is parents or guardians to provide the opportunity for education to his child, or as the case may be, ward between the age of 6 and 14 years. Article 53 says that the executive power of the Union shall be vested in the President. The President is the head of the Indian state, but he is only a nominal executive head. The oath of the office of the President is administered by the Chief Justice of India and in his absence by the senior most judge of the Supreme Court. The President holds office for a term of 5 years. He can resign from his office at any time by addressing the resignation letter to the Vice President of India. The President is elected by the member of the Electoral College consisting of A. The elected member of the both House of the Parliament. B. The elected member of the Legislative Assembly of the state. The nominate member of the Rajya Sabha. The nominate member of the State Legislative Council in case of the bicameral legislature do not participate in the election of the President. The President's election is held in accordance with the system of proportional representation by means of the single transferable vote and voting by a secret ballot. The President can be removed from the office before completion of his term by impeachment for violation of the Constitution. The impeachment charges can be initiated in either house of the Parliament. The impeachment motion can be introduced only when not less than 1/4 of the total number of the members of the originating House have signed the proposal, and a 40 days prior notice should be given to the President. An election to fill the vacancy in office of the President occurring due to his death, resignation or impeachment or otherwise shall be held within the 6 months from the date of occurrence of such a vacancy. The Vice President is ex officio chairman of the Rajya Sabha. The Vice President is not a member of the Rajya Sabha and hence he has no right to vote. Being a Vice President of India, he is not entitled for any salary, but he is entitled to The salary and allowances payable to the chairman of the council of the state. The vice president is elected by the electoral colleges, consist of the member of the both house of the parliament in accordance with the system of proportional representation by means of a single transferable vote. Vice president could be removed from his office by the resolution of the Rajya Sabha passed by the effective majority and agreed by the Lok Sabha. The president is entitled to get a monthly salary of 5 lakh, monthly salary of the 5 lakh. The vice president as a chairman of the Rajya Sabha is entitled to get monthly salary of 4 lakh. Article 76 stated that the president shall appoint a person who is qualified to be appointed as a judge of the Supreme Court to be Attorney General of India. He is the first law officer of the Government of India. In the performance of his duty, the Attorney General shall have right to audience in all court in the territory of the India. He is not paid a salary but a retainer that is determined by the president. The retainer of the Attorney General is equal to salary of the judge of the Supreme Court. The Comptroller of Auditor General (CAG) is appointed by the president for the full term of 6 years or the 65 years of the age, whichever is earlier. The CAG shall be removed in the same manner and on the same ground as judge of the Supreme Court. The Central Vigilance Commission was set up by the government in February 1964 on the recommendation of the Committee on Prevention of Corruption headed by the K. Santhanam. Article 75 first, the Prime Minister shall be appointed by the President and other ministers shall be appointed by the President on the advice of the Prime Minister. As per the Article 75 subclause 3 of the Council of Ministers is collectively responsible to the Lok Sabha, i.e. if the resolution is defeated in the parliament, the entire ministry collapses. The ministers are responsible individually to the president. A person not belonging to any house can be appointed as a minister, but he has to get elected to either house within the period of the 6 months. Article 75 subclause 5. According to Article 75 subclause 2, minister hold office during the pleasure of the president. The president is the head of the state while the prime minister is the head of the government. The prime minister recommends the person who can be appointed as the minister by the president. The prime minister is the leader of the lower house of the parliament. He can recommend for the dissolution of the Lok Sabha to the president at any time. The prime minister is generally the leader of the majority party in the Lok Sabha, but there has been instance when the prime minister has been from the Rajya Sabha. E.g. example Gracia, Indira Gandhi in 1966, Indra Kumar Gujral in 1997, and Manmohan Singh in 2004 and 2009. The highest decision-making authority in our politico-administrative system is cabinet. There are 4 important cabinet committees: Political Affair Committee, Economic Affair Committee, Appointment Committee, and the Parliamentary Affair Committee. The first 3 chaired by the Prime Minister at least, and the last one is chaired by the Home Minister. Parliamentary Affair Committee chaired by the Home Minister. Of all the cabinet committee, the most powerful is the Political Affair Committee, often described as the super cabinet. There shall be a parliament for the union which shall consist of the president and the 2 houses to be known respectively as the Council of State, the Rajya Sabha, and the House of People, the Lok Sabha. Though the president is not a member of the either house of the parliament, yet he is an integral part of the parliament and performs certain function relating to its proceeding. The Rajya Sabha consists of two categories of members, elected and nominated, who are the member for the period of the 6 years. They are indirectly elected by the member of the state legislature. 1/3 of its members retire every 2 years. The Rajya Sabha represents the federal character of the constitution in parliament. The Council of State shall consist of A. 12 members of the nominated by the president in accordance with the provision, and B. not more than 238 representatives of the states and the union territory. There are two occasions on which the joint sitting of the parliament is convened. A. Special address by the president. B. For resolving any deadlock over the passage of a bill. In the constitution, the strength of the Lok Sabha was provisioned to be not more than 552, i.e. 530 from the state, 20 from the union territory, and 2 nominated from Anglo-Indian community. But after the coming into the force 104th Constitutional Amendment Act 2019 from 25 January 2020, the maximum strength of Lok Sabha can be 550 because it has abolished the practice of the nominating two members from Anglo-Indian community. Thus, after 25th January 2020, the maximum strength of Lok Sabha can be 550, 530 from the state and 20 from the union territory. At present, the strength of Lok Sabha is 545. The money and the financial bill can only originate in the Lok Sabha. The life of the Lok Sabha can be extended by the Parliament beyond the 5-year term during the period of national emergency proclaimed under the Article 352, but this extension is for a period of not more than 1 year at a time. A governor usual term of the office is 5 years, but he holds office during the pleasure of the president. A governor can also resign any time by the addressing his resignation to the president. A person may be appointed as a governor for any number of the terms. A governor usual term of the office is the 5 years, but he holds office during the pleasure of the president. A governor can be resigned any time by the addressing his resignation to the president. A person may be appointed as the governor for any member of the terms. The salary and allowances of the governor are drawn from the consolidated fund of a state. The governor is entitled to the salary of the 3,50,000 per month. No criminal proceeding can be initiated or continue in any form as long as the person holds the office of the governor. However, no such immunity is available in the case of
सुप्रीम कोर्ट के न्यायाधीश की 2.5 लाख की.
However, no such immunity is available in case of civil case. The only respite being that governor should be given a 2-month prior notice containing full detail of such proceeding. A court cannot issue an arrest warrant or other punishment during his term of his office. Governor appoints the Advocate General of State and determine his
head of the
remuneration. The Advocate General holds the office during the pleasure of the governor. The governor appoints the chairman and the member of the State Public Service Commission. However, they can be removed only by the President of India, not by the governor. It is noteworthy that arrangement of the nominating representative of Anglo-Indian community in the Lok Sabha and in the State Legislative Assembly have not been extended beyond the stipulated date 25 January of 2020 by the Constitution 104th Amendment Act 2019. Thus, the arrangement of the nomination of 2 members in Lok Sabha and 1 member of Anglo-Indian community in Lok Sabha and Legislative Assembly has ended after the coming into the force of 104th Constitutional Amendment Act 2019 from the 25th January of 2020. If Vidhan Parishad is also in existence in the state, the governor has the power to nominate 1/6 of the total member of the Vidhan Parishad from among the person who have excelled or have practical experience in the field of literature, science, art, cooperative movement, and the social service. A governor is an integral part of the state legislature. He has the right of summoning or proroguing the state legislature and dissolving the state legislative assembly. Governor can address the state legislature at the commencement of the first session after each general election and the first session of each year. The governor can promulgate ordinance when the state legislature is not in session. Article 213. These ordinances must be approved by the state legislature within the 6 weeks its resembling. He can also withdraw the ordinance anytime. Money bill can be introduced in the state legislature only with the prior recommendation of the governor. Money bill can be introduced in the state legislature only with the prior recommendation of the governor. A governor can grant pardon, reprieves, respites, and remission of the punishment or suspend, remit, and commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of the state extends. Governor is constituted by the president while governor is consulted by the president while appointing the judge of the concerned state of high court. Governor is consulted by the president while appointing the judge of the concerned state high court. Governor make appointment, posting, and the promotion of the district judge in the consultation with the state high court. Article 233. The chief minister shall be appointed by the governor. Other ministers shall be appointed by the governor on the advice of the chief minister. The chief minister allocates, reshuffle the portfolio among the minister. The chief minister can ask a minister to resign or advise the governor to dismiss the minister in case of difference of opinion. The Advocate General is the first law officer of the state. He is appointed by the governor and hold the office during his pleasure. The legislature of every state consists of the governor and one or two houses. As per the constitution, the number of the member of the legislative council is not to exceed 1/3 of the total strength of the state assembly. However, its strength should not be less than 40 either. The strength of legislative assembly should not be less than 60 or more than 500. The General Council consists of the Union Home Minister, who is the chairman of all the council, and the chief minister of the different states are member of the different General Council. Panchayati Raj was constitutionalized through the 73rd Constitutional Amendment Act 1992. In January 1957, the Government of India appointed Balwant Rai Mehta Committee to examine the functioning of the Community Development Program 1952. This committee recommended Panchayati Raj all over the country. Rajasthan was the first state to establish the institution of the Panchayati Raj. The scheme was inaugurated by then Prime Minister Pandit Jawaharlal Nehru on 2nd of October 1959 in Nagore district. In December 1977, the Janata government appointed a committee on Panchayati Raj institution under the chairmanship of Ashok Mehta. The system of urban local government was constitutionalized through the 74th Constitutional Amendment Act 1992. Initially, there was a Chief Justice and the 7 other judges in the Supreme Court. At present, the strength of the Supreme Court is 34, one Chief Justice and 33 other judges. Article 129 of the Constitution declare that the Supreme Court shall be a court of record and shall have all the power of such court, including the power to punish for the contempt of itself. The Chief Justice of India is entitled to recovery. The Chief Justice of India is entitled to receive a salary of the 2,80,000 per month, and the other judges of the Supreme Court receive a salary of 2,50,000 per month. A judge of the Supreme Court after retirement shall not be legal practice in any court in the territory of India and shall not plead before any authority under the government. Article 324 of the Constitution provides that the power of the superintendence, direction and the control of the election to the parliament, state legislature of the office of the President of India and the office of the Vice President of India shall be vested in the Election Commission.
हाँ अबे